intends to.
Welcome back. You're watching Plain Speak. The Collegium debate has been reignited yet again. Well, when did it die down? The judiciary versus executive war has refused to die down, with slots coming in, with attacks coming in from both the sides. Today, the Supreme Court warned the union government, saying that any delay in clearing recommendations regarding the transfer of judges between various high courts can result in administrative and judicial actions. Justice Kaul on the bench said that delay in deciding on the transfer of high court judges may result in both administrative and judicial actions, which may not be palatable. I'm quoting from the judge. You had Law Minister who also rigged up the issue of pending cases. There was a written response that was filed in Lok Sabha. And he cited various reasons as to why there is huge pendency in the cases at various high courts. There were multiple reasons that were cited, but one of the reasons, according to the ministry, is the vacation period of the courts. It's one of the many reasons for the pendency of cases. And this is not the first time. You would know that the centre and judiciary are at loggerheads with each other. This is a fight for transparency, or this is a fight for control. The reform of Collegium system, or the appointment of judges in this country, is an issue that has continued to dominate the headlines. The Law Minister even said that the government should have some kind of representation at the search committee level. The Collegium should reform itself because it's in violation of various orders of the Supreme Court, which have spoken about large-scale reforms that need to take place. So who should appoint the judges in the country? In India, which has had a wonderful constitutional evolution and history, why is it that the system of appointment of judges remains opaque? Now, the argument is that the government is against Collegium. The current system is opaque, it's not transparent, there is no accountability. The judiciary has been against NJAC. That is one of the key reasons that it was struck down by a constitutional bench. The court is of the view that the government has undermined judicial independence via NJAC, and that is why that law was struck down. There's also an empire within an empire in Supreme Court. That's what the barb is, which has come in from the union government. Well, the judiciary says that primacy in appointments and judicial appointment need to remain with the Chief Justice of India. Talking about the Collegium system and who is to blame for the high judicial vacancies, you have the government saying that the vacations, high number of writ petitions or the PILs taken by the court are the cause. And judiciary is against the NJC, judges appointing judges. That's another one reason that the Law Minister cited. You also have the voices saying that the politics cannot influence judiciary. One of the key concerns of the judiciary has been the political interference in judicial appointments. The dark period that the Supreme Court and the high courts of the country saw during the emergency era is a scar that has not gone away, and those memories continue to dominate the manner in which the relation between the executive and the judiciary has evolved. It is one which is riddled with many conflicts, and more importantly, there is a complete lack of trust between both the sides. Now, talking about this fight that continues to intensify and talking about where should the public interest lie, we should know how our judges are appointed, what are the parameters, what does the Supreme Court Collegium or a government looks at while they give an assent for a judge to be appointed. Whose right is supreme? I guess it's the people. We discuss tonight. Well, joining us on the broadcast is Mr. Aryama Sundaram. He's a senior advocate at the Supreme Court of India. Good evening, sir. It's a pleasure to have you on the broadcast. Not the first time that we are discussing this issue, but a very serious observation coming in from a Supreme Court bench, which says that if the transfer of judges between various high courts is held by the government or is delayed by the government, there can be administrative action or action on the judicial side. Do you see this as a potent escalation?
Well, according to me, it was an inevitability. I think the court gave a long enough rope to the government to follow the law. And when the government still seems to be averse to following the law which has been laid down by the Supreme Court and which under Article 141 of our Constitution is the law declared by the Supreme Court as the law of the land. When the government is showing a hesitance to follow the law, I think it was inevitable at some stage the patience of the court would run out. And what the court's direction or what the court's observation today was really saying that, look, if you don't follow the law, the court can direct the government to follow the law, not merely by administrative interplay, but by a judicial order, because there is a legal duty for the government to follow the law. And if the government fails in following the legal duty, in complying with its legal duty, that is when the court comes in to direct the government to act in accordance with law. But let's understand the genesis of this whole issue. And I don't see what is happening today, why all of a sudden it's becoming such a huge issue. The very basic structure of our Constitution is separation of powers. And separation of powers is that there has to be a complete independence of the judiciary. What happened way back during the time of emergency and otherwise, when it was the executive who was appointing the judiciary, and the judiciary itself had no role, except, as the executive liked to term it, advisory. There was a lot of flack which came up about the manner and the nature of appointment of judges and what was following, resulting in the famous judgment of the Supreme Court, which clearly laid down that the Collegium of the Supreme Court, to maintain the independence of the judiciary, will be the best body to decide as to judicial matters of postings, of elevations, of transfers. And
Mr. Sundaram, with due respect, please allow me an interjection. Please allow me an interjection. With due respect, there's an interjection that I want to make. Does the separation of power, or the term quote-unquote judicial independence, mean that the government cannot have any role when it comes to initiation of the names for elevation at High Court or at the Supreme Court? Or the government, compared to the present system of appointment, they cannot have any greater say. The case that the government is trying to push is of reform. They are saying, yes, Collegium exists. It exists as the law of the land. But under the judgments, the second part of the NJC judgment itself, there are various reforms that has been advocated by the Supreme Court itself. And under those reforms, we should have some more say. Any further say of the government, does that conflict with judicial independence?
In fact, there is no doubt about the fact that the executive can have a role. You asked me specific questions, let me give you specific responses.
Yes.
Number one, can the government initiate appointment of judges? Definitely yes. It is always open to suggest to the court, to the Collegium, to consider the elevation of certain people as judges. Two, can the government have any role in the elevation of judges? Answer, yes. And do they have a role? Certainly yes. Because what happens is that the Collegium gives its recommendations to the government. The government then can consider it. The government can thereafter send it back and bring to the notice of the Collegium various aspects, why they feel someone's elevation is suitable or not suitable, or why a transfer is suitable or not suitable. And then it's a duty of the Collegium to consider all that. And after they consider it, if they send it back to the government, they can either accept what the government says, or they can modify their view in some way, or they can send it back to the government and reiterate it. Now, when they reiterate it, the government is bound to follow it. The point here is the buck has to stop somewhere. It can't be court to government, government to court, court to government, government to court, and nothing happens. Now, you ask the third question, and let me answer you very clearly. Can the government not have a role? I, for once, have always advocated this fact that an NJC is a very good idea, that it can be duly represented by the judiciary. It can be represented by, and of course, if you take somebody like the Prime Minister, if he's on the body to select for the elevations to the Supreme Court, a person like him will want the best of the country, someone like the Prime Minister, maybe the leader of the opposition, yes, and that would work, but the final say has to be left to the judiciary. They can be involved in a collective decision making. If it is unanimous, well and good. But if there is some kind of a tie, then the tiebreaker should be the judiciary. Why did the NJC fail the Act? Because the Act said the tiebreaker has to be the executive.
No.
Now, the whole point was, the NJSC did not see it as a collective decision where if there is a disagreement or if there is a split, the Chief Justice will decide. They made it that the assent of the executive was a must.
Yes, yes.
Now, the moment that comes in, the independence goes. So it is not as though there cannot be a collective body, but the collective body has to be such that when push comes to shove, if there is a split in the decision, it has to be the judiciary to decide. And that preserves the independence of the judiciary.
Sir, to put it into context for our viewers and in the larger public interest, you're a veteran at the bar. You have seen how the Collegium has evolved, how the judicial appointments are made in this country. And you would know better than me that the standoff between the government and the Supreme Court Collegium is not new. We have seen it earlier as well. I remember the last incident was when there was the Chief Justice of India, Justice T.S. Thakur, and Law Minister was Mr. Ravi Shankar Prasad, and there was this open confrontation of sorts that had happened between the judiciary. Even that time, then Chief Justice of India had warned the government that we will pass judicial orders if you do not listen to us. Is this another round? Is this another bout between the government and the judiciary? Or perhaps you sense there's a serious thinking within the government that there can be steps to bring in some kind of legislation for the reform of the present collegium system. What's your understanding, sir?
Let me tell you something. The government can always bring in legislation. They can bring in legislation which, as long for the selection of judges or otherwise, constitutional amendments, which, so long as it maintains and subserves the separation of powers and independence of the judiciary, can be upheld. You can change the system. You can change the system from collegium to something else. But whatever system you change has to see that the separation of powers is maintained, that the independence of the judiciary is maintained, and the judiciary cannot be selected by an executive, because then what happens to separation of powers? Don't forget one thing, that the very concept of separation of powers is that each different power does its activity, and the judiciary's role in separation of powers is to ensure that all other branches do their activities in accordance with the Constitution.
Yes, yes.
Now, you are always going to have conflict, because if the executive acts in a manner which maybe suits the necessity of the day, but maybe against basic constitutional requirements, the judiciary may turn around and say, I'm sorry, that is not permissible. Now, if that happens, there will be a conflict.
Sir,
but the very concept of separation of powers in itself is something which will always result in conflict in whichever country. It's not India.
I agree with
Wherever there's separation of powers, there has always been conflict at some stage or the other, because one is the watchdog of the other, and there is nothing wrong in that.
And that conflict perhaps is to guard the larger public interest, as you're saying. Sir, as I end this wonderful discussion with you, I want your opinion and your candid opinion. Are you an advocate or a proponent that the reform of the Collegium should be done through a piece of legislation preserving the primacy of the Chief Justice of India, because this is a matter that has been pending too long for judiciary to do it by themselves? And if there is a piece of legislation that preserves the primacy of the Chief Justice of India, preserves the core of the separation of powers as you're talking about, then perhaps it can be a good idea.
Yes, I believe that would be a good idea. I believe that will take part, the government, instead of the Collegium making a suggestion, government looking at it on its own, giving its recommendations, sending it back, and then it going back and forth. If there is one body, but the primacy of the judiciary, ensuring separation of powers, independence of the judiciary is maintained, I'm sure such a legislation would be ideal, and that will have a large base, exchanging of views, both by the executive and the judiciary, to hopefully come to a unanimous conclusion. But if at all there is not, then the primacy of the Chief Justice has to be maintained.
Well, voices like you from the bar, I guess, should be heard from both the sides, sir. It's always a pleasure to have you on the broadcast. Thank you so much for joining us. I'm going to take all those points to Mr. Vikas Singh as well, who's a senior advocate at the Supreme Court of India and also a president at the Supreme Court Bar Association, joining us on the broadcast. Good evening, Vikas Singh. Thank you so much, sir, for speaking with us. I remember having this conversation with you earlier as well, and you had pointed out that the government is completely free to bring in another constitutional amendment, or they are completely free to bring in another piece of legislation which preserves the primacy of the Chief Justice of India. Before we go as to what may happen further, how do you see these recent attacks from the law minister when he says that one of the key reasons of pendency of cases at the high courts is because of the vacations that the courts take?
Well, as far as vacations are concerned, the law minister has to understand how the system works in the judiciary. And because he's never practiced law, so obviously he has had no first-hand experience of the functioning of the judiciary. The vacations are an integral part of our functioning, and it is necessary because if you see the way the judges function, they sit in court from 10:30 to 4. They read their briefs before coming to the court, and invariably there are 60, 70 briefs to be read in a day for each one of them. And then they also deliver judgments at home. Now, if there is the longest judgment, it may take hours to dictate that judgment. And I remember once Justice B.N. Karpal was sitting in the High Court and he dictated a judgment for 3 full days. He just came to court and dictated a judgment, and he used to dictate that judgment. Now, if judges start dictating judgment in the time which is supposed to be the time, which people feel is the time where the judges are actually supposed to be working, then you can imagine that no hearing will take place. Not a single hearing will take place if a judgment of that kind, or longest judgment, is dictated for 3 days. Then 3 days, no litigant will get any matter being taken up. So the law minister obviously does not know the system of how the judges function. And if this kind of functioning, if you don't take a proper break, and we all look forward to this kind of a break, even for lawyers, basically it's a break without, there is no payment because there is no, we're not on salary. So the moment we take a break of this kind, we have to be completely without any payment for this entire period. And very few of us actually work in the vacations. Most of us completely leave the court and leave the city and go away. So this lack of understanding of the working of this system is the result of this kind of a statement.
I wonder if this is a lack of understanding, or the matter has really gone bitter between the Supreme Court and the executive, that these kind of barbs are taken. And this was not an oral statement, mind you. It was said through a response on the floor of the House in Lok Sabha. I must reiterate that there were multiple reasons that were cited as to why there is high pendency. But one of the reasons cited was also vacation. Coming to the second aspect, there is an open warning that has come in from the Supreme Court that if the transfer of judges at various high courts is delayed by the government of the day, there would be action on the judicial side or on the administrative side. How do you see this warning coming in from the court?
So, Anusha, it's very, the constitution as it is today, if there is something against a particular judge, or if a particular judge, is not behaving properly, the only action that can be taken against him is to, impeach him. Which has to be done by 2/3 majority of the parliament. Invariably, it has never happened, and it has never succeeded, and the parliament is not in the control of the judiciary. So what happens is that when they recommend the transfer, it is mostly, or I would say 99%, for administrative reasons, where they feel that the particular judge in a particular high court has developed some kind of a nexus, which they feel is not desirable, or it is not good for the functioning of the judiciary, or for the way in which the judges should behave and function. So a transfer is then sought to ensure that this kind of deviant behavior is curtailed, and if he goes to a new place and if he knows that he's under transfer for this reason, obviously he becomes careful, and he invariably it results in people self-correcting themselves. Now, this is the only corrective mechanism which the Collegium has to ensure that wherever they have some kind of a complaint of this kind, which is not of the kind where the parliament will go in for an impeachment, then they do this transfer. Now, if these transfers are delayed, then it gives an impression that the judge is playing politics, because he's trying to ensure with the government that he stays in a particular place. And that is a very, very disturbing thing, because that really shows that the judge, that further, justifies the transfer.
So, believe that there is ground for the Supreme Court to take action on the judicial side?
I think the Supreme Court has dealt with the, with the central government with, I would say, kid gloves. And in a contempt petition, even till date, no contempt notices have gone.
Okay.
So if contempt notices had gone, probably by now things would have sorted out. But the Supreme Court also, considering the delicate nature of this balance between the judiciary and the executive, is trying to sort of fine tune things to ensure that it doesn't escalate very much, and that is why these.
I discussed this proposition with you earlier as well, and I remember you saying, and we were discussing this with Mr. Aryama Sundaram as well, that if the primacy of the Chief Justice of India is preserved, then another piece of legislation, if the government decides to bring in, it can survive the test of the Supreme Court as well. This latest standoff between the government and the judiciary is not something that has not happened earlier. It has happened earlier. We have seen earlier Chief Justice of India and the Law Minister involved in a bitter war. It happened during the tenure of CJITS Thakur as well. And then the Law Minister was, Mr. Ravi Shankar Prasad, and even that time there was a bitter confrontation. It happened in an open court as well. What is it that makes this confrontation far more serious in nature? Because with every passing day, it only escalates. What is the logical conclusion of this kind of escalation, or I must rather say the tutu meme that we are witnessing from these two key constitutional pillars of our country?
Well, Anusha, it's a little unfortunate because, if the Law Minister says that judges should not hear bail matters, and bail is a matter of personal liberty, then again that shows complete lack of understanding of the importance of civil liberties in this country. If the learned minister says that the Supreme Court should not hear the BBC ban case, now that is something which is to do with the freedom of speech and expression, which is a fundamental right guaranteed even to non-citizens. So if you can't, if these issues are not to be taken up by the Supreme Court, then what else is the Supreme Court supposed to do?
Yes.
But having said that, this escalation of this tutu meme has resulted because they are a bad loser. So when they lost the NJC, they lost it on a very small window that they wanted to have the privacy of appointing or rather having the final say of appointment.
Yeah.
And I've been crying hoarse. I've also drafted a piece of legislation, given it to the Law Minister. He's also mentioned it in the Parliament.
Yes.
The window to bring in a new law has always been there. I mean, if you want to actually, if you're really interested in good people being appointed, and if the real interest is not just to control, I mean, there are two aspects,
Sure.
One
Reform
is
to
get the best people to be appointed in the judiciary. That should be, I would say that should be the, interest of both the judiciary and the government.
Okay.
So if that is the real reason, then I don't understand why do you want to have the final say on the appointment. You can always do that by bringing in, legislation to see that what is the such.
And I completely agree with you there, sir, that there are multiple aspects, multiple layers of Collegium and how it operates, and there are various things that can be done without attacking the primacy of the Chief Justice of India or the final word that the judiciary wants to have. And all eyes on that piece of legislation that you've drafted and presented to the Law Minister. Let's see what happens. Will the government bite the bullet? And will there be another piece of legislation that they present in the Parliament? Thank you, Mr. Vikas Singh, for joining us on the broadcast, and thank you for your time. This entire battle is far from over. Will it finally result in government bringing in another piece of legislation for the reforms which are pending, or the Collegium will take up the process of reform from within? All eyes on that development. Well, moving on and getting you some key stories from across the country. Prime Minister Narendra Modi participated in a Kirtan program via video conferencing today. The prayers were held in Assam's Barpeta. The Prime Minister also addressed the devotees. The month-long Kirtan began on the 6th of January and shall be convened in the next few days. Hundreds of women held protests against the Civic Supply Department in Puducherry. The protest was held demanding the closure of restaurant bars and reopening of ration shops. A video of a speeding car dragging a motorcycle for about 4 kilometers in Gurugram went viral on social media. After a probe, the accused was arrested and his car was taken into custody. An incident of fire has been reported near Bhavan of Mata Vaishno Devi Cave Shrine. The fire was brought under control and no loss of life or injuries has been reported. The cause of fire seems to be a short circuit. The US has accused China of operating a spy balloon over sensitive locations housing nuclear weapons in Montana. President Joe Biden has been briefed on the possible options for a US response, including using fighter jets to shoot down the balloon. Experts are saying that it could flare up the tensions between the two countries ahead of a visit to Beijing by Washington's top diplomat. And US President Joe Biden hosted former President Bill Clinton at the White House. He invited Clinton to celebrate the 30th anniversary of the Family and Medical Leave Act. Catholic worshippers in Mexico City marked the end of the Christmas period with a procession and a mass in honor of baby Jesus. The festival is one of the most important religious events in Mexico's calendar. A retired police officer dog was rescued in California after the animal fell in the well. The German Shepherd was being walked by a US Navy veteran when the dog disappeared into a well's opening that was covered by a bush. Israeli Prime Minister Benjamin Netanyahu met with the French President in Paris. Macron offered to help revive long-stalled dialogue between the Israelis and the Palestinians. A New Jersey woman who was recently elected to her borough council was shot to death. She was shot multiple times and died on the spot. Now, she was elected for the first time in 2021 when she ousted a Democratic incumbent. And a baker from Switzerland has set the Guinness Book of World Record by making the world's largest wearable cake dress. Leaving you with these visuals.